Start. Sir, I rise to speak on a very important organization, the National Technical Research Organization. First, I will dwell on this subject a little before moving to the main debate which is going on regarding the phone tapping. The NTRO simply provides the technical capability. Now it is true that technology has moved much beyond what was perhaps envisaged when the group of ministers met in 2001 or when the NTRO was set up in 2004. Now, when the technology moves forward very fast, we cannot lag behind. We have to acquire the technology. In fact, let me assure the honorable members the technology that the NTRO has is not as sophisticated as it is made out. In fact, I am privy to knowledge which I acquired recently that there are other organizations in the world which have technology far superior and many years ahead of the technology the NTRO has today. In fact, when I visited one of the countries, I was one of the few who was allowed full access to what they have, and what I saw amazed me on the one hand and to some extent frightened me on the other. That kind of technology is available among a few countries in the world. We do not have that kind of technology. The NTRO has acquired the technology. That technology must be put to use, and that technology must be put to use subject to very stringent safeguards. The leader of the opposition used the words technology bugs. Technology does not bug. It is the use of technology and the user of technology who bugs. Technology by itself does not bug anything. We have a machine. The machine does not do anything. It is how the machine is employed, where it is employed, who uses the machine, and under what conditions the machine is used. We are therefore, as I said, in the process of reviewing the entire functioning of the NTRO and putting it in place safeguards that will keep pace with the technology that NTRO has acquired, and if I may say so, that NTRO will acquire in the future. I cannot say that NTRO will not acquire new technology. It will acquire and it must acquire. But we must put in place safeguards that will keep pace with the technology that we may acquire in the future. Now, sir, coming to the question of balancing the right to privacy and the right and duty of the government to gather intelligence and the safeguards, I completely endorse what honorable member said. There is no partisan view here. I endorse what the leader of the opposition said, and I endorse what other members said. We have to constantly be on the whistle, constantly review the safeguards and procedures in place and update them so that they keep pace with the technology that we have to acquire. Sir, an impression was created as though telephones are being tapped only in the UPA government. I think anyone who has been in the government knows that it is not correct. I can say with complete conviction that all authorized tapping is authorized for no more than 60 days. Telephone interceptions can be extended again for another period of 60 days and again for another period of 60 days by the Home Secretary, who is the sole authorized officer in the Government of India for reasons to be recorded in writing on requests made by the agencies concerned. Let me also take you into confidence that the decision does not go beyond the Home Secretary. He is the sole person to take this decision. No minister is involved in this decision. Please remember the same power is available to the Home Secretary in the state. The discussion here seems to point a finger only at the Home Secretary in the Government of India. There are 30 other Home Secretaries in the states who have the same power. So, as you have said, and I take it in good spirit, the safeguards must be applied to the Government of India. Please remember the same safeguards, if not more stringent safeguards, must be applied to the states too. Therefore, each one of you who represents a state must carry the same message to your states to ensure that the Home Secretary in the state also abides by the same strict safeguards before he or she authorizes any telephone interception. The reasons why I am saying it is because this is the Council of States. There is no other way we can function. We have to entrust this power to someone. This power is entrusted to a high government official, and at the state level, I believe it is entrusted to a high government official, and the fact that they have to record reasons, maintain the records for a certain period of time is the only safeguard that we can think of. But we are working on further safeguards. We will amend the rules. We will write further safeguards as and when the situation requires, and I think the situation does require that we must take into account changing technology. Sir, I do not wish to dwell on the individual cases. Much has been said, but I think it would be unfair or completely improper for me to dwell on any cases. If cases are under investigation, they will be investigated. No one has stopped investigation of any case. The cases being investigated will continue to be investigated to a logical conclusion, and if any evasion is found, any violation of law is found, whatever the law provides, we will follow. On the issues raised by many of the members, I am glad that it is recognized that there are legal and authorized interceptions and there may be unauthorized illegal interceptions. I speak for the government when I say that every interception authorized by the government is perfectly legal, like it has been in the past, like it has been between 1999 and 2004. If there has been legal or authorized interception, If our inquiries reveal that there has been any illegal or unauthorized interception, we will go to the bottom of the matter. We will find out who is responsible and we will take action against those who are responsible.